there each time has only strengthened, and my knowledge in criminal law specifically has only deepened. But to explain why I've left several times, I'm happy to answer that. I believe that exposure to various areas of laws is important and is crucial as an attorney in general. Obviously, we are required to supplement our knowledge through continuing legal education, but nothing makes up for actual experience and actual practice in different areas. And so I wanted to make sure that I at least had exposure to that. My first experience was with the law office of Lee Van Ossen, which primarily dealt with estate planning, probate, a little bit of guardianship. And so I was exposed to that area of law, and I found that experience invaluable. Probate is a very specific area of law, can be repetitive, but the details matter. Any deviation from that can be detrimental not only to the client, but also to the judicial process and slow the process in general. So I thought that that experience was invaluable. I do not see myself at this moment as a transactional attorney in terms of my practice, which is why I returned to the Public Defender's Office. In terms of my second experience outside of government service, which was at the law office of Douglas Bean, a wonderful mentor to me. I was exposed to civil law at that time. And again, another invaluable experience, another area in which attorneys should be exposed to be able to be before this commission and be able to say they're prepared to enter into that exposure of law. At that time, I was exposed to the world of case management orders, mediations, settlement cases, motions to dismiss, the civil procedure that's required to be able to handle a civil case from start to finish. And so, again, I wanted to be in the courtroom. I love criminal defense. I love criminal law in general specifically. And so at that time in my career, I wanted to make sure that I was remaining true to that. And so that was the reason for that departure.
Okay, thank you.
Hey, good afternoon.
Good afternoon.
Just to clarify some of that dynamic. So when you were at Beam's office, that's when you were exposed to litigation?
Yes.
Okay, so it was just those 4 months that you were there that you were exposed to civil litigation?
Yes.
Right. And it's when you were at Van Fozen's office that you were exposed to the estate planning and probate?
Yes.
And so that was about 6 months or thereabouts?
Correct.
Okay. So all the other time you practiced all been
Criminal defense, yes.
Okay. So to give you an opportunity to sort of address this issue, I expect the thoughts running around in people's minds like, does this person have the experience, that makes them the best fit to be on a circuit court bench, not county court, but circuit court, with not a ton of experience overall, and almost all of that being criminal. The civil experience is relatively small compared to a normal practice. Right? So can you flesh that out and sort of provide your perspective as to why that's not a barrier?
Sure. I believe that, again, exposure is everything. I will completely agree. I don't have years of experience in civil or probate. However, as mentioned, the reason I did make that departure was to at least be able to say I've been in a litigator's shoes for probate purposes. I've been in the shoes of someone who has had to file a motion to dismiss or defend against a motion to dismiss. I understand what it is to meet and confer. I understand the deadlines that are imposed by case management orders and why they're important. I understand that terminology, and I think that that is invaluable in and of itself. While it is short-lived, I can't deny that. I did think that that exposure was invaluable, and I do believe that that's what's going to be needed long-term as a circuit judge. I know that this is a question that is often posed to many applicants, especially when they have a heavy area of practice of law, which mine is criminal defense. But I did try to get that exposure. I do have that hands-on knowledge, and I am ready to supplement that as needed. Again, that's my position on that.
Thank you.
Good afternoon.
Good afternoon.
So I had the pleasure of vetting you, and I want you to know there's people were quite prolific in telling me about you. And so I didn't hear anything bad, so I want to play the devil's advocate, right? So you are a public defender, that's all you've done is, other than your stint with Doug Beam and Andy Van Fossen. What would you say if somebody said, if you're going to make a bench, if you're going to sit on the bench, you're going to be a judge, how would you address maybe a concern that you would lean more towards the defense, or that you'd be more concerned about how certain outcomes would affect defendants rather than following the law?
In terms of my case analysis and how I practice personally, I've always thought that the best way to advocate for a client is being able to see it from both perspectives. You have to be able to do that to properly advocate for your client. So many times I don't start from wearing a defense hat. I'm actually looking at it from the state's perspective. What is the strength of their case? What witnesses or evidence is going to carry the weight during this particular charge or elements of charge? So in terms of whether or not I would be defense-oriented, my application was dedicated to answering that exact question. My goal is to be objective. I've done that as a litigator, as a trial attorney, and I would plan to do that as a circuit judge.
Thank you.
Hello.
Hi.
So I spoke, I think, with every single circuit judge, and among other people, and I will echo Scott's sentiments. Universally, you were well respected, and I wanted to tell you that. And I've heard that ever since you started your career with, I think I first heard it from Doug Reynolds, the public defender's office. So I think that it's very admirable that you're applying, and I think that you have, in a short period of time, developed a good reputation, and 60 jury trials, which we've interviewed other people who have been at a prosecutor's office for a lot longer, who have fewer jury trials. I think that's certainly commendable. So I think that you're well positioned so far. The concern that Scott raised, I think, may be a concern from the governor's office as well, is this particular governor has appointed a lot of prosecutors. You have the perspective of being a public defender, and so along the lines of satisfying any concern that you're not going to be defense-oriented, I want to expound on that a little bit. What is your judicial philosophy, and how does the role of the judge differ in the application of that philosophy than being an advocate as a public defender?
I think that I could sum up my judicial philosophy in two concepts: objectivity and adherence to the law. That is what I would aim to apply in every case that would be before me. I do understand the Commission's concern. Having a defense background can be seen as one way. However, through my trial experience, going to those jury trials and some non-jury trials, my job is to make sure when I'm in the courtroom, I'm prepared and I know the state of the law from both sides. I know my weaknesses, I know my strengths. There are times where I have to make concessions because the law tells me so. I would apply that same philosophy on the bench. I would not go into it with the defense mentality or the prosecutor's mentality. I want to look at the law, hear the arguments before me, and make a fair ruling based on the law and the law alone. In terms of my particular background, although it is defense-oriented, I think that my trial experience is what speaks volumes. I have a very good awareness of the procedures that are going to be needed in every facet of each stage of the criminal aspect specifically. I have a wonderful knowledge when it comes to the application of the rules of evidence. I pride myself on my motion writing, the strengths of my evidentiary arguments before the courts, and I have that experience. So yes, I have a shorter amount of years, but I have packed them with depth and knowledge and true experience.
Very good, thorough answer. I want to make sure that the rest of us get a chance to ask.
Good afternoon. So I want to sort of follow up on the same theme, the question of your experience. had roughly 2 months as a civil litigator. You know, if I guess, sort of, summarizing your resume. This position right now is certainly criminal, but as I'm sure you're well aware, that's not always the case. So, so the first question is, what would you do to be prepared? And I have a short hypothetical.
Sure. To be prepared, one, I do think that the reason I'm applying at this point is I am an appropriate fit at this time. Obviously, I will need to be prepared, and I am prepared to make sure that I can segue into any further court assignment or docket assignment that's necessary. Obviously, that's needed for any sort of judge. But I am an appropriate fit for what is needed at this time. I have that background and experience. My plan to be prepared will obviously be to expound on the hands-on knowledge that I was able to receive firsthand, and I would make sure that I'm continuing to observe these civil cases. I would make sure that I am, just as any attorney would do, continue to supplement my legal education, rely on, if appointed, my judicial mentors as well. So I do think that there's a variety of different resources available that I would make sure that I'm using properly. But again, as mentioned, although short, I do have that experience. I know in terms of the terminology, the types of motions, the typical civil procedure, I do have experience with that. I am familiar with it, and I will expound on it.
Let me ask you the brief hypothetical. You're sitting on a civil trial. Parties have stipulated to the law. You've heard the evidence. It's 50-50 on liability. How would you rule a lie?
In terms of,
Plaintiff or defendant?
so in terms of a preponderance of the evidence, it's 50-50. I don't know if I'd be able to make a ruling at that point, especially if it's the burden is on the plaintiff.
Is it preponderance of the evidence 51%?
Yes, and you say your hypothetical was 50-50, so,
So the
yeah,
plaintiff loses.
correct, I would deny the motion.
Good afternoon, Mr. Rivera.
Good afternoon.
Can you tell me, the commission, what inspired you to apply for this judgeship?
I think at this time that I am at a point in my career where I believe I have valuable perspective and insight to offer. I wanted to apply because I am very dedicated to public service. That is what keeps me at the public defender's office. I want to be committed to our county, people of Brevard County, and so that is what inspired me to apply.
Thank you.
I'm thinking a lot of my questions have been asked. What I'm trying to weigh is, are you ready now? Right? You're doing really well. I'm thinking county court versus circuit court. Is this your time? Convince me.
That's a very fair question, and I hope that you won't be deceived by my perhaps youth or even shorter term of experience. I'm getting close to, I'm at 9 years of experience at this point. I'll be at 10 very soon. But as I mentioned, numbers aren't everything that matters. It's also the depth of experience, right? I can tell you that I have walked in many a courtroom. I'm confident, I'm prepared, I'm educated on the law, and I take the experience of each jury trial with me. I've learned, I've sharpened my craft, and in terms of county versus circuit, because I do believe that many times this commission is asked the difference between someone serving county versus circuit. I believe circuit is where our complex and serious cases are heard, and I respect that. I currently am constantly trying to improve my depth of knowledge. I'm currently participating and assisting on death penalty cases, so I do have the ability and experience to handle those complex and serious cases.
Thank you.
Do you have any concluding remarks?
I do want to thank the commission for their time, their dedication, and the hours that must have taken to go through each each candidate, especially myself. I want to end with simply this remark that if the commission were to consider me for the next phase to the governor's office, the commission would be sending a candidate that has true travel experience, that is educated, that is knowledgeable, and that will only improve over time. Thank you.
Thank you for the time and for putting a lot of effort into your application. All right, Ms. Moody?